See, you keep talking. I got one more, Mr. Miller. You keep talking to me. This is going to go sideways. You know what? Sometimes people keep talking when they may be winning.
Oh, okay.
Your attorney did a great job. The only thing you're going to be able to do is mess it up.
I'm sorry.
So if you want to keep talking, I'll listen. But I'm just letting you know.
No, Your Magistrate. No.
You're done?
Yes, sir.
Okay. On the felony case, I'm going to give you another shot. You don't show up, then you're going to be sitting in jail for a long time. I'll set his bond at a personal recognizance, $10,000 bond. I'll reinstate his previous conditions.
I want to say one thing. Can you give me some?
Your name, sir?
David Childs.
Thank you.
I'm sorry, Your Honor, Mr. Childs just said something. Could I get clarification?
You may want to hit the button so we don't have to go ready to go.
All right, thank you, Your Honor. Okay. At this time, my client wishes to waive the preliminary examination. He's going to sign the waiver form right now, and we'd like to address bond.
Yeah. Is there a reason all my informations are missing? Like the second file. Sir, you're waiving your right to a preliminary examination?
Are you waiving your right to a preliminary exam, sir?
Yes. You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them. You understand you'll not have that hearing and that you'll proceed to circuit court.
Yes, Your Honor.
For further resolution. People also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on both counts.
Your Honor, we acknowledge receipt of the information. Waive, it's on the record, and at this time, my client wishes to stay on mute and have the court enter a not guilty plea.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for April 7th, 2026, 1:30, Judge Conkey. As to bond.
Your Honor, we're requesting that that the court would consider one of two options for Mr. Childs. The first is to grant him a personal recognizance bond. He has been in custody for, I want to say, 2 months at this point.
Longer than that.
At least 2 months at this time. He is a small business owner. He owns his own flooring company. He can return to that work. He can be released on tether to the address in the file and has no problem with the no contact order or a no go to that area order. Part of the reason for my confusion or not being quite clear about his dates is because this case is a reauthorization case. However, the original felony was reduced and was pending in district court up until yesterday. So with that, in terms of the total time with regard to these incidents, it would be more than that.
Response.
This case is right. This is a reauthorization. It originally was an exam and was remanded. However, right after they reached out to let us know that she hadn't made that court date or wanted to participate and was still scared of this defendant. She was present today. We talking about it. He was waiting. I would object. He has 2 previous domestic violence convictions from 2023. In this case, he pinned the victim to the ground, put his knee to her neck, and punched her in the head. She had a front back neck. He also grabbed her by the shoulder, spit at her along with pushing her around the house. So given that, I would ask for bond remain as set, Your Honor.
And did the previous, are they involving this same individual or no?
Yeah.
I do not believe so, Your Honor.
I mean, I don't know that either one is good, but anything else, Ms. Kane?
Our alternative request would be a release to substance abuse treatment.
I don't have a problem signing release to substance abuse or inpatient treatment.
Yes.
And so if that order's prepared, I'll sign that. But as to the changing of the bond to a personal recognizance, that motion is denied.
Would that be with the tether?
It would be with the GPS teller. That's,
All right, thank you.
thank you. Court calls the cases of the people versus Shane Morgan.
Good morning, Marty. And again, the people.
He already put his appearance on, Mr. No.
Assistant Public Defender Ben Dunaway on behalf of Mr. Morgan, who appears to my right, would you please state your name for the record?
Mr. No contest. I don't know why the heck they don't have it ready, but I'll do it, but I'm not gonna do it right now. It's got to. Court does call the case of the people versus Jesus Hernandez Palestino.
Morning, Your Honor, Raymond Cook. Assistant Public Defender Ben Dunaway on behalf of Mr. Hernandez Palestino, who stands to my right, would you please state your name for the record, sir?
Jesus Hernandez, Your Honor.
And Your Honor, this is the date and time set for preliminary examination on this matter. At this time, I think you'll be unable to proceed as to the original charge count one. I would be moving to add a misdemeanor count two of receiving.
I'll need a complaint.
I'll file an amended complaint immediately afterwards.
What is it?
Tax code for that is 750.5354A.
And that's what's
It's a 1 year, 2000s receiving, concealing, 200 to 1,000.
as to the arraignment on that charge, you waive presentation of the complaint.
And yes, and stay in mute, waive the formal reading.
Court will enter a not guilty plea as to that count two. Count one is dismissed. People being unable to proceed. I'll set a pretrial in this matter for
16. I mean, yeah.
April 16th, 2026, 9 a.m. before Judge Garwood. Bonds will continue.
Thanks, Judge.
We're gonna. I didn't get to. Okay. Court does call the case People versus K. John White.
I'll check people, Your Honor.
Michael Gaddy, Assistant Public Defender for Mr. White, who is approaching the podium, Judge.
State your name.
A1 White.
Big one. What are we doing?
Your Honor, this time, necessary people are not present.
Move to dismiss, Judge.
People being unable to proceed this case is dismissed on defendant's motion. That's without prejudice.
Thank you.
Thank you.
Yes, Your Honor.
Anything else ready? Not ready? You're ready? Are you gonna let us know? Because I don't have a file. It's not your fault. It's Joe Hall's. What are we doing on yours?
My understanding is it's supposed to be
No,
the waiver.
there's gonna be a dismissal of the felonies and the misdemeanors today, Judge Barr. All right.
That was way too much detail for him to made it up, but.
I'm not taking
No.
the rest of that, Judge.
What'd you say?
I'm not taking blame for the rest of
Is
it.
that, are we ready on it?
Yep, yes, we're ready.
Court calls the case People versus Kenya T.
Michael Vincent on behalf of this. Put your name on the record.
Kenya Teets.
Robert Evans, prosecuting attorney on behalf of the people.
Michael Vincent on behalf of Mr. T.
Can you teach?
Did we just do that? It's like Groundhog Day.
Practice.
All right, what are we doing?
Adding count 7 and 8, which is child. I
Guys, they what? Go ahead.
got okay.
You have
I will file a amendment complaint as soon as I get.
why don't we have that ready to go? That's two of them. People, if we're gonna do it.
I apologize. Wrapped it up right now.
Fancy, okay.
Hey, that might be helpful. Because that other file, I'm waiting on the other one right now, and I'm not gonna do it this way. So, sir, you'll have to have a seat. You gotta get the paperwork to me, and I'll be more than happy to get it resolved and get you on your way.
Thank you, sir.
All right, thank you. Anything else that's not ready? You have that police report?
I do, Your Honor. It's 2 cases.
2 police reports?
Yes.
Do they have a plea for on or about November 3rd, 2024 at the location of 2nd Street and Frederick Street in Ypsilanti City, Washtenaw County, State of Michigan, that you did have improper possession of a financial transaction device. Do you understand the nature of that charge, sir?
Yes, Your Honor.
All right, that is a felony punishable by up to 4 years incarceration and $5,000 fine plus court costs. You understand that?
Yes, Your Honor.
All right. Sir, first question I have for you is, do you wish to be represented by counsel?
Yes, Your Honor.
All right, this is a public defender case.
Good afternoon, Your Honor. First Assistant Public Defender Kalina Anderson within on behalf of Mr. Henning. Your Honor, we stand mute and reserve the bond argument.
All right. Defendant having waived formal reason standing mute, court will enter a not guilty plea. And you're demanding a preliminary examination?
Yes, Your Honor, we'd ask for a PCC date, please.
PCC, all right. PCC will occur April 2nd. April 2nd, 2026, 9 a.m. As to bond. Anything from the people?
Your Honor, Kenneth Waters is a prosecuting attorney. Mr. Henning is currently held on an armed robbery charge. I believe Pierce bond is denied on that matter. He's also held on a probation violation in circuit court. We would ask that the court set a cash bond in this case.
Response.
Your Honor, as to bond, we're just requesting a low cash bond. This is a non-assaultive case in FTD with the offense date of November 2nd of 2024. He is being held currently without bond. Given that, we would ask for the court's consideration of a low cash bond of 1,010%.
Regard to defendant's bond, I'll order standard conditions, including no assault behavior or possession of any weapons. There should be no use of any alcohol, recreational marijuana, or any illegal drugs. I will set the defendant's bond in an amount of $10,000. I'll give $10,000 cash surety on this. All right. Anything further on this matter?
Nothing from the people. Thank you, Your Honor.
No, Your Honor, thank you.
Thank you. Oh, that's right. I don't get another file until Who's that new PD?
You can.
No, I don't. No, I'm not going to ask her. I'm not asking. No, I'm not asking her. Actually, her and I go way back. It's like bugging the hallway. I was minding my own business. It was horrible, the whole thing. You didn't know that we knew each other, did you, Miss Sanders?
No, I didn't. I was waiting to do an introduction, but if you already know her, that's even better.
I don't know anything about her. She came in. She said,
I know that you know all, Judge.
Yeah,
it
I
does
do,
not surprise
but-
me.
she just said, I'm a new PD. I said, all right. She didn't even give me her name. She just
They didn't even tell you her name. I don't believe
no.
that.
You know, it was sort of rude. but it's okay.
Oh,
Felony.
Not a new felon. All right. Court does call the case People versus David. Is it Wilhelmi?
Wilhelmi, yes.
Sir, say what's your name?
Wilhelmi.
Wilhelmi. All
Yeah,
right.
close.
Sir, you are before the court on a felony complaint that has two charges. All right. The complaint alleges that between the dates of June 27, 2024 and October 3rd, 2024, at the location of 6800 Geddes Road in Superior Township, Washtenaw County, State of Michigan, count one alleges that you did embezzle $50,000 or more, but less than $100,000 or more. Do you understand that nature of that charge of embezzlement, sir?
Yes.
All right. That makes this a misdemeanor, or I'm sorry, a felony, punishable by up to 15 years incarceration, a $25,000 fine, plus court costs. The fine could be increased to 3 times the amount that was embezzled. If that's greater than $25,000, that would become the maximum fine. You understand that, sir?
Yes.
I did say a 2-count, it's actually a 1-count complaint. Sir, the first question I have for you is, do you wish to be represented by an attorney?
Yes. I got it.
Public defender case.
Good afternoon, Your Honor. Assistant Public Defender Alexis Zerps with and on behalf of Mr. Wilhelmi. We will stand you to the charge, reserve our bond argument, and request a PCC date be set.
Set a preliminary exam or preliminary exam. Probable cause conference in this matter will be set still on the 2nd.
Yes.
April 2nd, 2026, 9 a.m. Esteban, go ahead for the people.
You know, the people do not object to a PR bond in this matter. We'd ask for a no-go to the Hyundai American Technical Center at 6800 Geddes Road in Ypsilanti.
You said you have no objection to a PR.
That's correct, Your Honor. The defendant has no criminal history.
Got it.
We ask you have no contact with any employees of the Hyundai America Technical Center.
Response.
Thank you, Your Honor. At this time, we'd also be requesting a personal bond. As the people indicated, Mr. Wilhelmi doesn't have any criminal history. This is an older offense dated June of 2024. It wasn't charged until this month. It's a non-assaultive charge. He's the father of a 15-year-old son, and he is currently seeking out employment options, but in the time being, he is doing Uber Eats and door dashing. So he is staying busy. He has no issues with complying with any no contact or no go to order set by Your Honor, as he does reside in Westland. So I believe that will create some distance between him and the old place of employment.
Court will set the defendant's bond in $25,000 cash or $25,000 personal recognizance bond. Other standard conditions, including no assaultive behavior or possession of any weapons, no alcohol, recreational marijuana, or any illegal drugs. He is not to have any contact with any employee of Hyundai America. You understand that, sir?
Yes.
In the 6800 Geddes Road address, that is the employment address, Mr. Overwater.
That is my understanding, yes, Your Honor.
Going to indicate you are also not to go to the 6800 Geddes Road address in Superior Township. You understand that, sir?
Yes, I do.
All right. Anything further?
Nothing from the people.
Nothing from
Thank
defense,
you.
Your Honor. Thank you.
Thank you.
You know, these. Thank you, sir.
Thank you.
Sport. Yeah.
Yeah, they always say. Pretty much.
Hmm.
They said they don't say.
Right.
Oh, come over here. You wanna go first? You're a loop.
Name.
Yeah, man, how you feeling? Wow, man, hangover. Way more.
Gotcha.
They did the last one, but you wanna ask him?
Sir, what is your name?
Angel Lupin Contreras?
Did you need a Spanish interpreter?
Nope.
No? Okay. Just wanted to make sure, so that's not the one.
That's how it's flagged. But if he says like.
Okay. He says no, it was good. This is the ring on bench warrant. He was previously arraigned. All right. Court does call the case of the people versus Lupion, or actually it's, they've got this all in here wrong. I think it's, is that how your first name, sir?
Angel?
Yeah, Angel. Okay.
Yeah, it's the same thing, but Angel, yeah.
Angel Lupion Contreras.
Yeah.
All right, this is a PD case.
Good afternoon, Your Honor. Assistant Public Defender Alexis Earps with and on behalf Mr. Lupian Contreras. And it's my understanding this is a failure to appear for a pretrial hearing on the February 18th.
Yes. Is there a reason why you didn't appear, sir?
Yeah, because I
Your
never got
Honor.
a notice, but I understand why I didn't get a notice.
Your Honor, if I may, so one of the bond conditions for his case is not going back to his regular address because the complaining witness also resided there. And at the time he was originally arraigned, he did not know the address of where he was going to be staying. He is currently staying with a friend. He did provide me with that address, so I did give that to the court on the CAA form. So I believe that that issue would hopefully be resolved and he could appear for any future court dates set by Your Honor.
Well, is that the reason he didn't appear?
That is my understanding, Your Honor.
You gotta retrace that for me, Ms. Earps. He's arraigned by the magistrate on 2/10. He's given the date to appear and he doesn't appear. And you say it has something to do with the address?
Your Honor, so he indicated to me he missed hearing the date during the arraignment, and then he was expecting a notice in the mail. And the address the court had on file was for an address that he's not allowed to go to. So I'm assuming the notice went to that address. He did not have where he'd be staying at the time of his original arraignment. I do now have the address of the friend he's staying with, and I did provide that to the court on the CAA form. So I'm assuming mail may have gone to the wrong place.
He couldn't call the public defenders?
Your Honor, we did have a discussion on that's what he should do in the future because it sounds like he may have also not heard any kind of reminders from my office as well.
Oh. Okay. All right. Reset is bound to be happy. What do you have? I have a 5,000 first. However, she said it's bound to a $5,000 personal recognizance bond. I will. The conditions previously set will apply. I'll reset the pretrial in this matter. It's mine. What day?
April 15th.
April 15th, 2026, 9 a.m. That's before me. Did you hear that date this time, sir?
April 15, 9 a.m.
You got it.
Yeah.
Okay. No more excuses.
Yeah.
We'll see you. Thank you.
Thank you, Your Honor.
He's arraigned on a new felony. He's in a different one.
He is, okay, there he is. Got it. Court does call the case of the people versus Orby Huffman. Sir, your name? He's muted.
Orby
All
Huffman.
right. Your name, sir?
Orby Huffman.
All right. Mr. Huffman, you are before the court on a felony complaint that alleges that on or about February 27, 2026, at the location of 2201 Hogback Road, Pittsfield Township, Washtenaw County, State of Michigan, that you did assault a prison employee. Do you understand what you're charged with, sir?
Yes, sir.
That is a felony punishable by up to 5 years incarceration and a $2,500 fine plus court costs. Do you understand that?
Yeah, I hear you.
All right. Do you wish to be represented by an attorney, sir?
No, I'll represent myself.
Okay. Are you representing, let me just ask you this. Are you representing yourself on the reason why you were there at the jail?
He is not, Your Honor.
Part of the evidence I would like to submit.
Hold on a second, sir. I need you to answer my question. Are you represented by the public defender or someone on the matter which you're in the jail for?
No, I'm representing myself. I've told them I'm going to represent myself.
All right.
Your Honor,
All right.
he's currently represented by Mr. Burgess on that matter.
I got you. All right, sir, I do have to apprise you that there are certain dangers in representing yourself. You understand that, sir? The court is going to hold you by the same standards that the court would hold you to as if you were an attorney. And that includes your knowledge of the Michigan court rules and of court procedure. You understand that, sir?
Yes, sir.
I do have to advise you once again that it is not wise to represent yourself in this matter, but if the offense that you are charged with is a felony punishable by up to 5 years and a $2,500 fine plus court costs. Do you understand that, sir?
Yes, sir.
All right. Do you still wish to represent yourself?
Yes.
Then I'm going to give you a formal arraignment so that you know exactly what the charges are. The complaint alleges that on or about February 27, 2026, at the location of 2201 Hogback Road, that on that day you did, being a person lawfully imprisoned in the Washtenaw County Jail or other place of confinement established by law, did assault Diego Paz, an employee of the place of confinement or a custodian, knowing that person to be an employee or custodian, through the use of violence, threats of violence, or dangerous weapons while awaiting trial. You understand that?
Yes.
And you do understand the maximum penalties that I previously described?
Yes.
All right. I will indicate that you're standing mute to that charge. I will enter a not guilty plea on your behalf. You understand that, sir?
Yes.
All right. I will then set the matter for probable cause conference, April 2nd, 2026, 9 a.m. You understand what you need to do for that proceeding, sir?
Yes.
Anything you want to say regarding bond? I'll hear from the people first.
Your Honor, people would be asking for a cash bond in this matter. Mr. Huffman's currently held on an aggravated stalking charge. That charge, those facts are alleged against his brother. That matter is currently set for trial before Judge Conlon on April 13th. Mr. Burgess is the attorney of record and remains the attorney of record. In this matter, I had the opportunity to review the video. It shows a deputy walking along a catwalk in one of the pods. Mr. Huffman walks towards him and then, for no apparent reason, attacks the officer, grabs him by the head. The officer tries to radio for help. Mr. Huffman tries to keep him away from the radio. The officer is able to get to the radio and ask for help before Mr. Huffman drags him into a cell and slams the door behind them. Officers had to come up, open the door, enter, pepper spray him, and take him into custody. The officer was not hurt. Mr. Huffman did grab him by the neck, but did not strangle him. That's why he's not charged with assault by strangulation. But under the circumstances, we would ask for a cash bond.
Sir, anything you want to say regarding bond in this case?
Yeah, it said that I grabbed him by his neck. I never did. You might want to take a look at that video.
All right. Anything else?
That's all.
I will order bond set in the amount of $50,000 cash surety. I'll order standard conditions, including no assaultive behavior or possession of any weapons or ammunition. There's to be no possession or use of any alcohol, recreational marijuana, or any illegal drug. I will indicate you are also not to have contact with individual alleged in the complaint, that being Diego Paz. You understand that, sir?
Yes, sir.
Anything further from either side?
Nothing from the people. Thank you, Your Honor.
Thank you.
The next gentleman back in the other box, he has 4 misdemeanor arraignments.
All new ones?
All new ones, yep.
All new ones. All right. And that's Mr. Hernandez. Court does call the cases of the people versus Alfredo Hernandez. I have 4 cases before me. All right. Your name, sir?
Alfredo Hernandez.
All right. Mr. Hernandez, you are before the court on 4 misdemeanor citations or complaints. The first one, that being case ending in it's 252-0470, is a misdemeanor complaint that alleges that on or about July 10th, 2025, at the location of 617 North Prospect in the city of Ypsilanti, Washtenaw County, state of Michigan, that you were involved in an accident and failed to provide information or render assistance after that accident. You understand the nature of that charge, sir?
Yes, sir.
All right. That's a misdemeanor punishable by up to, I believe it's 90 days and or a $500 fine plus court costs. You understand that, sir?
Yes, sir.
The case 252-0471 is also a misdemeanor citation, so I can locate it here. Paperwork. That alleges that on or about July 10th, 2025, at that 617 North Prospect in the city of Ypsilanti, state of Michigan, that you did fail to report an accident. You understand the nature of that charge, sir?
Yes, sir.
That is a misdemeanor punishable by up to 90 days and or a $500 fine plus court cost. The case 252-0472 is a misdemeanor citation that alleges that on that same date of July 10th, 2025, location of 617 North Prospect, city of Ypsilanti, that you did drive while your license was suspended, denied, and or revoked. Do you understand the nature of that charge, sir?
Yes, sir.
That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs, and your vehicle could be subject to immobilization. You understand that, sir?
Yes, sir.
The case 252-0473, that case alleges that on that same date and at that same location of that 617 North Prospect in the city of Ypsilanti, Washtenaw County, state of Michigan, that you did commit an offense of violation of a city of Ypsilanti ordinance by not having insurance on the vehicle. You understand that, sir?
Yes. Can I say something real quick?
Hang on a second.
Oh, okay.
That is a misdemeanor punishable by up to 90 days and I believe a $100 fine plus court cost. You understand that, sir?
Yes, sir.
All right. Sir, I wouldn't want you to say anything. You understand that anything you do say can and will be used against you. You understand that, sir?
Yes, I just wanted to say about the insurance. I did have insurance.
Hold on a second, sir. I don't want you to say anything about any of these offenses, all right, at this time.
Okay.
I don't think would be beneficial for you. My first question to you is on any of these, do you wish to be represented by an attorney?
Yes.
Yes.
Do what now, Matt? Sir? Can you
Pardon?
repeat that?
Oh, okay. Do you wish to be represented by an attorney?
Oh, yes.
Yes, I thought that's what you would say. All right, these are public defender cases, Miss Anderson.
Thank you, Your Honor. First Assistant Public Defender Kalina Anderson with it on behalf of Mr. Hernandez. Your Honor, we would stand mute to the charges, all 4 charges. And at the appropriate time, I'd ask to address bond.
Defendant having waived further formal reading, standing mute, court will enter a not guilty plea. I don't have anything from the people, so yes, go as to bond, please.
Thank you, Your Honor. As to bond, we would ask for a personal bond in all 4 matters. My client lives in Ypsilanti. He's a father of 4, and he just started employment doing home remodeling yesterday. He does not obviously want to lose that employment by remaining in custody. He would ask for the court's consideration of a personal bond, as these are all traffic matters and non-assaultive in nature.
Hearing no opposition to it, the court will order bond set in each of these cases a $5,000 personal recognizance bond. I will order standard conditions, including no assaultive behavior and no possession of any weapons or ammunition. There's also, sir, at this time, not to be any possession of any alcohol, recreational marijuana, or any illegal. You understand that, sir?
Yes.
Okay, fantastic. Thank you. Oh, I gotta give a date. Miss Anderson always makes me forget that. What day?
April 14th April 15th at 8:30 with Judge Barr.
Pretrial in these matters were April 15th, 2026. What time?
8:30.
8:30. That is before Judge Barr. Okay.
Thank you, Your Honor.
Thank you. All right.
2 more defendants, 3 cases. I don't have it just yet.
Good. Van Blarkian.
In this tense courtroom moment, the judge warns the defendant to stop talking before things get worse. The defendant keeps trying to speak, but the judge makes it clear that his attorney already did a good job arguing the case, and continuing to talk could only damage his chances. Despite the tension, the judge still decides to give the defendant another opportunity, setting a $10,000 personal recognizance bond and warning him that if he fails to appear again, he could be facing serious jail time. So here's the question: should the judge have given him another chance, or was this already too much patience from the court?
What? I don't know how to pronounce her name. She wouldn't give it to me before.
I apologize. I was trying to remember the message I had to deliver. It's Van Blarkum. Like there's no I there.
Oh, just Van Blarkum.
Yep.
Okay, I won't remember that. So, but it's okay. So hold it. There were supposed to be like a whole pack of you guys hired. Why is there only one running around? They didn't let the others out.
They decided I was the only one that could be free for now, Your Honor.
Where are you from, young lady?
I actually live right here in Ypsi, but I was practicing in Detroit. I was practicing with Lakeshore Legal Aid for a long time, doing eviction defense.
Ah, fantastic. And so where'd you go to undergrad?
I went to undergrad at MSU, and then I actually have a master's degree from Eastern and law school at Wayne State. So.
Okay. The whole Spartan thing, that was going to be a problem. The only thing that saved you there is Wayne State.
I'm a warrior now, sir.
Yeah. Now she could go on our good list.
Arraignment on a new felony.
New felony. All right. Court does call the case of the People versus Daryl Gardner. Sir, state your name, please.
You just said it.
I'm sorry?
I said, you just said it.
I know. Are you Daryl Gardner?
Yep.
Okay. That's what I needed to just make sure. That's why I'm asking you to say it. All right. Gardner, you are before the court on a felony complaint that alleges that on or about March 2nd, 2026, at the location of 2201 Hogback Road in Pittsfield Township, Washington County, State of Michigan, that you did maliciously destroy fire or police property. Do you understand that, sir? Mr. Gardner, do you understand what you're charged with?
Yeah, somewhat, yeah.
Okay, but you understand specifically they're saying that you maliciously destroyed a jail cell door window pane. Okay, you understand what they're saying you did? I'm not asking you whether you did it or not, but you understand what they're saying.
Yeah, somewhat, yeah.
Okay. That's a felony punishable by up to 4 years incarceration and a $5,000 fine plus court costs. You understand that, sir?
Yeah.
Okay. First question I have for you, sir, is do you wish to be represented by an attorney?
Yep.
Okay, this is a public defender case.
First Assistant Public Defender Kalina Anderson, with on behalf of Mr. Gardner, Your Honor, we stand mute and request a preliminary a probable cause conference date.
All right. Defendant standing mute. Do the charges, court will enter a not guilty plea. Probable cause conference will be set for April 2nd, 2026, 9 a.m. As to bond from the people.
Thank you, Your Honor. Mr. Gardner is currently held without bond on a possession of methamphetamine charge before Judge Hammoud. He also has an unarmed robbery charge that's pending, I believe is set for probable cause conference before Your Honor on Thursday. Bond in that matter is set at only 1,010%. People would ask for a cash bond on this matter as well.
Response.
Thank you, Your Honor. Yes, that's correct. Mr. Gardner is being held without bond and has a lower cash bond in the pending PCC matter. We would ask for a low cash bond in this case due to the other holds.
Bond in this case will be set in a amount of $5,000. I'll give it 10% privilege on it. I'll order standard conditions, including no assault or behavior or possession of any weapons or ammunition, no possession of any alcohol, recreational marijuana, or any illegal drug. What I'll order at this time. I guess, counsel, do you wish me to move if he's got a prelim or a PCC set for this Thursday, did you want me to move this one up to that date?
Yes, Your Honor, if you would consider that so we can keep everything together.
All right, I'm going to set his probable cause conference for, March 26, 2026, 9 a.m. All right, that way to be together with the other case.
Thank
All right,
you.
anything further?
No, Your Honor, thank you.
Thank you.
Thank you.
Just insurance ones. This is a felony, the other one's a misdemeanor.
Just on the type form, so. Pardon?
Yes.
Court does call the cases of the People versus Anthony Miller. Case 24 F1 1184 and also Anthony Miller in case 1812689. You have the public defender already on these cases, Mr. Miller. All right. You there, Mr. Miller?
Come on up, Mr. Miller.
All right, you're there. Okay, go ahead.
Good afternoon, Your Honor. Assistant Public Defender Alexis Zerps with and on behalf of Mr. Miller. Your Honor, these are both failure to appear bench warrants. I'm prepared to address the court whenever Your Honor is ready.
All right. Well, let's see, let me reset it and then we can address his bond at that time. I'll reset his probable cause conference in these cases to April 2nd.
Excuse me.
2026 at 9 a.m.
Your Honor.
All right. Yes, sir.
I have a job and a volunteer job. And I was on tether was on tether. I was on tether. I still have my tether on, and I come up here to take care of this incident. When the police stopped me, I didn't catch a new prior.
Okay, Mr. Miller?
Yes, sir.
Okay, why don't we do this? You've got an attorney on both of these matters. Why don't we let your attorney address the court, okay?
Well, I was just was asking for leniency because I was coming up here to. That's why I was up in Washington County to take care of this matter. And then I had contact with the police, and then they came.
Mr. Miller, I'll explain all of that to the court, okay?
Oh, okay, because I was just wanting to know, because I didn't want to stay here till April 22nd.
And Your Honor, I believe one of these is a misdemeanor matter, so I didn't know if you wanted to set the pretrial date on that one too.
Yes, I will. What date are we giving it? 15?
You know,
Pretrial on that matter will be April 1st, 2026.
I don't want to lose my job.
At 9 a.m. Okay, Mr. Miller, hold on. Let your attorney address me.
Okay.
All right. Okay. Mr. Miller, hold on. I got it. I can't hear you and her.
Okay.
So I think you'd rather me hear her right now.
Yes, sir.
Okay, go ahead, Mr.
Thank you, Your Honor. Mr. Miller indicated to me that he was incarcerated at Wayne County Jail during the time of these court dates. I did reach out to Wayne County Jail, and I did get someone on the phone. Their process for requesting a proof of incarceration involves mailing out a money order, but she did look him up in the system and saw that he was incarcerated in August, which is when the probable cause conference date was. I did look on Wayne County Circuit Court website and search his cases, and it does look like there was some warrants issued around that time for some probation violations. So he was always aware of these court dates. However, he was unfortunately incarcerated elsewhere and was unable to come to court on these two dates. We'd asked for consideration of a reinstatement of a personal bond. And Your Honor, like Mr. Miller was trying to indicate, he did come to Ann Arbor last night knowing he had these warrants to take care of. And I had every intention of coming into court this morning to get them taken care of. He had just was recognized by police last night, and they brought him into custody on the warrants.
Okay. Anything from the people?
The people would object and ask the court to continue on a cash bond for this matter. Our records indicate that he had a bench warrant issue in September of 2024. And then I'm also showing that his failure to appear was in July, not in August on the probable cause conference case, but that could be a failure of our system. Regardless, he's shown that he will not come to court when he's ordered. He apparently does follow the rules of probation in Wayne County, and the felony charges allege resisting and obstructing. So it certainly would appear that he doesn't follow law enforcement's orders either.
May I say something? Your Honor, I am a good person, and I'm no threat to society.
You know what, Mr. Miller?
You
know what? Sometimes people keep talking when they may be winning.
Oh, okay.
Your attorney did a great job. The only thing you're going to be able to do is mess it up.
I'm sorry.
So if you want to keep talking, I'll listen. But I'm just letting you know.
No, Your Magistrate. No.
You're done?
Yes, sir.
Okay. On the felony case, I'm going to give you another shot. You don't show up, then you're going to be sitting in jail for a long time. I'll set his bond at a personal recognizance, $10,000 bond. I'll reinstate his previous conditions.
I want to say one thing. Can you give me
And see, you keep talking. I got one more, Mr. Miller. You keep talking to me. This is going to go sideways. And in the other case, I will set his bond at a $7,500 personal recognizance bond. All right. So you're going to get out. Then you got to show up for court. Make sure to keep in contact with your attorney and be quiet and listen to what they have to say. All right. Anything further from either side?
Thank you, Your Honor.
Nothing further, Your
All
Honor.
right.
Thank you.
Thank you. Is that it? That's hard work. No, I don't know that it is.
Despite the tension, the judge still decides to give the defendant another chance. Instead of immediate jail, the judge sets a $10,000 personal recognizance bond and reinstates the previous conditions. But the warning is clear. If he doesn't show up again, the consequences will be serious. So what do you think? Was the judge fair for giving him another opportunity? or should the court have taken stricter action right away?